Thank you for joining me at ELG Estate Planning. We serve clients from our offices in Spokane, Kennewick, and Seattle. One of our goals is to educate and to help people understand estate planning. And oftentimes people veer away from it because it seems too complicated. And that's why I'm so happy that you are here listening to our discussion today. Because when it comes to protecting your legacy, estate planning is a big part of that. And we're going to be talking about what the right estate plan is for you. Because by having the right estate plan, the right estate planning tools, and by understanding it, you actually are empowering your future, which is one of our goals at ELG Estate Planning. You will be protecting your legacy. We'll talk about that, and making sure that those people that you want to benefit from your lifetime, from the assets in your estate, will actually do so. When we talk about legacy, there's a couple of different ways, as I'm sure you know, that term is used. One of the primary ways is talking about, well, what impact do the events of your lifetime have on the world, on your family, on causes that are very important to you? How did your life matter? So that is one way to look at a legacy. And I'm sure if you look it up and look at a definition, legacy also incorporates wealth and inheritance, money that is inherited. And of course, estate planning talks about, and we'll be talking about, how to ensure the best protections for those who will inherit from you, from your estate. I will say, however, that one of the things that when people actually do an estate plan, they prepare an estate plan, they get the guidance that they need. It is an opportunity for them to think about what matters most to them in their life. How is it that their life is going to have the most positive impact upon those around you? So these are not mutually exclusive, these definitions of legacy. So we're going to get into talking about the right estate plan for protecting your legacy. One thing I want to mention, we're in August. This is, I think, National Make a Will Month. So if you're like me, you have been receiving emails from various places. Personally, I went to the University of Washington, graduated from the University of Washington Law School. I have received an email from the University of Washington suggesting that I make a will. Just this morning, from the World Wildlife Fund, I received another email with a link that said, make a will. So I have gone into these links because I think they were legitimate links. I wasn't worried about getting scammed, and actually went through the process of making a will. And I have to admit, they aren't bad wills, but I'm a lawyer. I understand what it means. I understand what these wills do not do. I understand that they do not provide any tax protections. Well, if you're giving your estate to a charity, it doesn't matter, right? But what if you're giving your estate to these charities after a spouse? Or what if you have you want to protect other people who are beneficiaries of your estate? These forms that are coming to you from these entities that want to receive your estate, or at least a part of it, when you're gone, they are not providing you the appropriate estate planning tools. And that's not just because they're providing a will, which doesn't have any of the protections that we'll be talking about that we recommend, but it also doesn't include really important documents, which are your living documents, your durable powers of attorney for finances, for health, your healthcare directive. It gives you no guidance on assets that don't pass through your will, your 401k, your IRA, your life insurance. So when you receive, because if you have made contributions to any charitable entity, my guess is that you have received these kinds of emails that I'm talking about. Just be aware that they are not a robust estate plan. They're not the right estate plan for anyone, in that they don't have enough to them. So I am not saying that you shouldn't consider charitable entities in your estate plan. Absolutely. If that's where a cause you believe in and you want to make sure your money goes to benefit that cause because it's really important to you, do so. But do so through an estate planning attorney, not through an online website. So estate planning to protect your legacy, to protect your money on your passing, to give those that you love and those who will be receiving money from you the gift of clarity, the gift of guidance, and to ensure that the maximum amount of your estate will go to them. How do you accomplish that? What's the right estate plan? So we're going to be talking about estate planning tools that take effect on your death. And the fundamentals are wills and revocable living trusts. And everybody is familiar with a will. You know that that is the legal document that you sign during your lifetime, following formalities so that the will is honored, and it directs with specificity, where does your assets go? Who gets them? That's a will. A will requires a probate. A will does not encompass all your assets. It does not encompass what we call non-probate assets, which are, as I mentioned, your life insurance, your IRA, jointly held assets, 401ks, etc. All of those are part of your estate. It's really important that they are coordinated with what your dispositive wishes are. The second fundamental dispositive estate planning tool is a revocable living trust. When people use the term trust, they likely are referring to a revocable living trust. A revocable living trust is a legal document that you sign during your lifetime in which you transfer your assets, your home, your bank account, you rename them into the name of the trust, and you likely are the trustee, meaning the person in charge of managing the trust, and the beneficiary. You get the benefit of everything in that trust. They are so transparent and such that they don't even have their own tax ID number. They use your own Social Security number for tax reporting purposes. So these are very commonly used, especially in states where probate is something to be avoided because there is no benefit. If you happen to be listening from California, you may well have a revocable living trust because it's very much suggested that in these unfriendly probate states, you have a revocable living trust. As I mentioned before, at ELG Estate Planning, we have offices in Washington State. Washington State is a very friendly jurisdiction for probate. And so oftentimes revocable living trusts aren't appropriate in Washington State. It all depends on what your circumstances are. We'll get into that in a little bit more detail. So I just want you to be aware that when you hear the term trust, typically it's about a revocable living trust, and it is to avoid probate. And that may be the right estate planning tool for you. Sometimes, though, when people use the term trust, they might be talking about a testamentary trust. What's that? That is a trust created by a will through a probate. Or they may be talking about an irrevocable trust. Now, why would somebody have a trust that's irrevocable? Well, there's a number of reasons, and it really depends on the person's situation why they might benefit from an irrevocable trust. An irrevocable trust has its own tax ID number because if you give your assets away to an irrevocable trust, You might be doing that to get those assets out of your estate so that they are not included within your estate for estate tax purposes. So folks with a taxable estate may very well benefit from an irrevocable trust. Tax laws are terribly complicated, so there's a lot of reasons why people might not want an irrevocable trust. It could have to do with capital gains issues, basis issues, etc. So if you're talking about an irrevocable trust because of tax reasons, you definitely will be talking to your tax estate planning lawyer. Making a mistake with a taxable estate will cause there to be very unfavorable tax consequences. So it's not something you do on your own. You don't do it with a form. You talk to the attorney that can help you with making sure your taxable estate, your irrevocable trust is right for you. Why? Because that's going to preserve your money for what you care about, people or charities. Sometimes clients use an irrevocable trust for Medicaid planning purposes, kind of like the opposite extreme. The reason that they do that is that Medicaid has a 5-year look-back rule. If you transfer assets to an irrevocable trust 5 years before needing to apply for Medicaid, Medicaid doesn't care that you did that. You can give away those assets as long as you do it 5 years in advance, and as long as you don't retain control or beneficial interest in that irrevocable trust. If your situation is that you are concerned about long-term care costs and that you want to make sure that you can utilize Medicaid benefits, then you'll be talking to an elder law attorney with expertise in Medicaid planning. Again, this is not planning you do on your own. Irrevocable trusts are not as common as revocable. Irrevocable trusts have their own tax ID number. They need to file their own tax returns. The trustee does. They do have asset protection, whereas a revocable living trust doesn't have its own tax ID number, doesn't file its own tax return, and has no asset protection. So it's not uncommon people come to me and they say, my friend said I need to have a trust because I need to protect my assets. And they're talking about a revocable living trust, to which I reply, your revocable living trust won't protect your assets. It's useful for managing assets, but not protecting assets from creditors, for Medicaid spend down, or for taxes. Again, I just want to mention, I'm talking about laws of the state of Washington. If you're in a different state, maybe it's a different outcome. Maybe your rules are different. Talk to an attorney, an estate planning and elder law attorney in your state. I just don't want you to think, if you're a Washington resident and you're listening, that a revocable living trust is going to protect assets for you, because it will not. A revocable living trust, the benefit of that is to avoid probate, which could be the right situation for you as long as you have properly managed and administered that trust during your lifetime, so that all the assets that can be in it are in it, and that upon your death, the successor trustee simply administers the terms of your trust, and it goes to those beneficiaries you want it to go to without the necessity of probate. So let's talk about, we're talking about legacy, and we're talking about legacy from an inheritance preserving money perspective. I was just talking about a revocable living trust. I'm going to talk about a will now. A will requires probate. So you might be saying, why in the world would I want an estate plan where probate is going to be required? There is a very compelling reason for that in the state of Washington. Several, but one of the main things that comes to my mind is that you can make sure that your surviving spouse will never become impoverished if you have the right kind of will with an asset protection supplemental needs trust in it. I know that's a lot of language, but what that means is that your will says, on my death, everything I own goes to this special trust for my spouse. My spouse is the beneficiary. My spouse cannot be the trustee or in charge of the trust. And it is according to what we call a discretionary standard as opposed to a support standard. Why that is so important is that when the state or the federal government is looking at, is this person the surviving spouse? Do they qualify for needs-based benefits? If the type of trust they have is a trust that was created by a will and it has discretionary standards and they are not the trustee, the government does not count those assets in the trust as belonging to the beneficiary, the person who would be applying for benefits. So it's a really valuable, useful tool to protect money for your spouse so they will never become impoverished because they can use government benefits to pay for things such as their long-term care, and they do not have to use all the assets from the deceased spouse that went into this trust created by their will. So I'm going to get into some actual fact patterns to help you understand that. But I also, when we're talking about, protecting money, it's typically we're talking about protecting money against long-term care costs and creditors and fraudsters is kind of like one way. And then there's also protecting money from estate taxes, because people that have a taxable estate, and in Washington, our estate tax level is fairly low. A number of states have no state estate tax. Well, that's not true for Washington. Our estate tax level is $2.193 million. And for folks who live in, a house that has appreciated in value quite a bit, and looking at what they have through their hard work put away during their lifetime, they could have more than that 2.193 million. So an estate plan needs to take that into account and make sure that regardless of whether it is a will that goes through probate or a revocable living trust, that within those estate planning documents, whomever is inheriting, especially if it's the spouse, does so with some sort of tax protection trust. They're called credit shelter or bypass trust. Just think of it as a tax protection trust. So anybody with a taxable estate should be talking to an estate planning attorney to make sure that they are not going to pay unnecessary estate taxes when the second spouse dies. The federal level in 2024 for estate tax is much higher, 13.61 million. In 2025, that sunsets, and depending on whatever the rules may change in 2025 as to what is the federal taxable estate level, and I'm not going to speculate on that because I do not have a crystal ball. But just know what this year is, 13.61 million per person. Next year, is it going to be 5 million? Is it going to be more than that? Time will tell. So we're talking about estate planning documents. What's the right one for you to make sure that you protect your money, your legacy when you're gone against paying unnecessary estate taxes? You can do that through a will that goes through a probate. You can do that through a revocable living trust that doesn't go through a probate, but in both of those instances, there needs to be some sort of tax protection trust for the surviving spouse. When it comes to not being worried about estate taxes, but making sure that your surviving spouse has money when you're gone, you're going to want to use a will and not a revocable living trust in the state of Washington, because it is only through a will that you can protect money for your surviving spouse by having that discretionary trust, that supplemental needs trust in that is created through the probate. The trust is in your will. It springs into life, so to speak, through the probate process. It puts your assets from your estate into that, and your surviving spouse gets to benefit from them, but then the government doesn't count that money as belonging to the surviving spouse. So I wanted to give you an example of what that would look like in terms of actual dollar amounts. Now, remember, to create that trust, that asset protection trust against long-term care costs, there needs to be a probate. So let me step back a minute. What is a probate? What does that mean? Most of you are probably saying, I've heard the term probate, and all I know is I'm supposed to avoid a probate. And that's not necessarily true. Avoid a probate if there's no benefit. Set up your estate to go through a probate if there is a benefit, especially if it is a large dollar amount benefit. So, probate. What is probate? Probate is a legal proceeding where the will is filed with the court. The personal representative, the executor of the estate, usually working with an attorney, has done a petition that says, here is the will. I've been nominated in the will. Here are the beneficiaries. This is all in the petition. Here are the heirs at law. And they sign an oath that's presented with this petition that says, and I'll do my job that the law says I have to do. That goes into the court. The judge signs off on the order that says probate is started. And in the state of Washington, where we have what's called non-intervention probates, meaning the court's not involved, the court will not be involved at all if it is what we call a solvent estate, meaning there's more money in the estate than there are liabilities. Then the personal representative just goes about their job of identifying the assets, gathering them up, paying any creditors that need to be paid. And in a typical case, if there's a surviving spouse with a surviving spouse trust, the personal representative puts the decedent's money into that trust and files a declaration of completion, and they're done. Usually it works best if there is an attorney involved to guide the process. And frankly, that's true for all estate planning. Usually the outcome is best if the person who prepared the estate plan had that expert guidance so that they understood the plan, so that it covers all of those situations where if there's confusion, that's going to cause trouble. You don't want your estate plan to be one that, you did on a 2-page form without any help. And the result of that typically is confusion, more legal costs when the person dies, and frankly, a lot of heartache because the things that should have been thought through weren't thought through. And that's really not the best situation for somebody to leave their loved ones with when they've passed. So an estate plan done with an attorney who understands what they're doing and how they can help you is obviously certainly what I would recommend to you. We are going to be talking about now the probate, and the probate with actual facts of how it works under a will where we're trying to protect money for the surviving spouse. So let's take a couple. Let's call them Joan and Stan, and they have a $1 million estate. Joan has advanced dementia, but fortunately, Joan and Stan prepared their estate plan while they both had capacity, while they both understood what was going on. They did not wait until it was too late, such that Joan couldn't do her own will and her estate plan. So that's pretty important. Now, even though Joan has dementia, Stan is caring for Joan in home, and that's really common that couples take care of each other and they do it in their home as long as they possibly can. But in this case, Stan dies. Remember, Joan has advanced dementia. She cannot stay in her house safely now that Stan is gone. So she likely is going to need to move to a facility. Let's talk about the money part of this and the will part of it and the probate part. So they have $1 million. So let's just say Washington's a community property state. So we know with a good degree of confidence that one half of that, or $500,000, is going to be protected for Joan. Half of $1 million is $500,000. That's Stan's share of the estate. Through his will, which is probated, the personal representative takes and puts the equivalent of $500,000 of property into this trust. It doesn't have to be one half of everything. It can be, we can do it non-pro rata. For example, we can put all of the money into the trust and keep the house outside of the trust. There's flexibility in how you fund this trust. But at the end of the day, the result is that Stan has passed. There's $500,000 in a trust for Joan, and Joan has $500,000 of her own. If you know anything about Medicaid, you know that a single person, which is what a widow is, can only have $2,000 in countable assets, but they can also own their house. And if they own their house, it doesn't count against them for eligibility. So in this situation, Joan is immediately eligible for Medicaid because the $500,000, which was liquid in my example, accounts, etc., went into the trust. The $500,000 that Joan has left is the house valued at $500,000. She's eligible for Medicaid. So there are a lot of practical barriers for her to immediately go on to Medicaid. But what I want you to understand is that from the legal perspective, Medicaid will accept her as an eligible beneficiary of the Medicaid program, which means Medicaid will pay for her cost of care at the facility that will accept Medicaid, even though she has a $500,000 house and $500,000 in this trust, because that trust will be honored by the state as an asset protection trust. So, is probate worth it? Let's say the probate costs $10,000. Okay. This couple protected $500,000 because they had the right will and it was done correctly, and $500,000 is in this trust and protected, all because there was a probate. The beneficiary of this trust is Joan, who has a trustee who's managing it for her. And then when Joan passes, where is that $500,000 going to go? Even though she's been on Medicaid, let's say for years, it's going to go where Stan said it was going to go in his will. Let's say that this couple had 2 children. It is going to go, that $500,000, what is left of it, is going to go to those 2 children. And keep in mind that none of it had to be spent on Joan's care. It can be, but it doesn't have to be, especially if Medicaid pays. So the state doesn't have any right to recovery for that $500,000 in trust. So it truly is a very robust, very powerful estate planning tool to protect money for a couple, for the surviving spouse, for the family, to ensure that money is left at the end of this couple's life for their children, assuming that that's where they wanted the money to go. That if we're looking at the term legacy and meaning money and inheritance, this is a very powerful tool to protect that legacy, because the money won't all need to be spent down on long-term care. It will be protected and preserved for those beneficiaries. So is probate worth it in that situation? Yeah. So one of the things that is really makes elder law attorneys happy is when we can have that kind of really profound impact on our clients' lives, because they worry that there won't be any money left at the end of the day. And through these kinds of estate planning tools and strategies, we're able to protect that money. So that is one of the reasons it's so important for me to share this knowledge so that you understand that you or someone you know or a loved one, if they're looking at just having in Washington a revocable living trust to avoid probate, but they're not multimillionaires. Maybe they should be looking at a will that will require probate because it will protect half, if not up to 100% of the couple's estate. All right, let's take a look at how do you protect your legacy with estate planning documents, not when you die, which we talked about, a will and a revocable living trust or irrevocable living trust, but you're still alive. Now, how do you protect yourself, your family, your money? What estate planning tools do you need while you're alive? If I recall back to how at the start of this conversation, I was mentioning that I have received emails from charitable organizations with a link to create your own will. There wasn't anything that said create your own durable power of attorney or create your own healthcare directive or create any of these essential estate planning documents that everyone needs during their lifetime. Nobody hopes that they ever have to use it, but if you do, you absolutely need to have these living documents. Because these living documents, which are the durable power of attorney for finances, the durable power of attorney for healthcare, the healthcare directive, also called an advance directive or a living will. These are your living documents. And why they are so critical is that they protect you if you should lose capacity, if you should lose the ability to make your own decisions. They protect your autonomy, your voice, make sure your wishes are heard, and they protect your money, and they keep your business out of the court. They keep the court away from your family, away from decision-making authority. How these documents do this is that a durable power of attorney is a legal document that you sign where you, as the principal, give authority to somebody you trust to act on your behalf when you're not able to do so. So if you should be in a bad accident, or you suffer a stroke, or have dementia, anything that causes somebody to no longer be in charge of their own life, there are these legal documents that put a trusted decision maker in charge of these decisions. And kind of backing up, nobody wants to be in that place where you can't be in charge of your own life. We all get that. But estate planning is all about proactive action to protect you in case that bad thing happens. So by doing these documents, you're not inviting incapacity into your life. You're just saying, hey, it's a possibility. I've planned for it. I've got the right documents in place. If it ever happens, then I know the court's never going to be involved in my life. Instead, it's going to be my husband or my adult child or a professional decision maker, a fiduciary, whatever your situation is, you're going to make sure that you appoint somebody that you trust, who knows you, who will take the action that you could take, will be your voice when you can't be your own voice. This is so important because what happens when you don't have these documents in place? So what happens when you don't have these durable powers of attorney in place is, and you are incapacitated and you don't have these documents, the court steps in. The court takes over your affairs. The court declares you to be, we used to use the term ward of the state, but you lose basically your autonomy completely. And who is the court going to appoint to be your decision maker? Is it going to be your spouse? Maybe. Is it going to be your kids? Possibly. Is it going to be a certified professional guardian because there's nobody else who is capable or competent or qualified? Yeah, that happens. That happens. That is not that unusual of a situation. So when there is a guardianship or conservatorship, when the court has stepped in, then all of your affairs become very public. Your personal care plan is filed with the court. Your financials are filed with the court. You have to sell your house, there has to be a hearing, a petition, order, notices. It goes on and on. Does this cost money? It costs money. It costs way more money than if you had gone to an attorney and put your durable powers of attorney in place that were appropriate and adequate and kept the court out of your business. So one of the things that you can do to empower your future, to make life easier for those in your family, for your loved ones, and to make sure that you are not wasting money on an unnecessary court-ordered guardianship or conservatorship, is to completely avoid it by having your durable powers of attorney. These are so important. And that's why I can't emphasize enough as an elder law and estate planning attorney, how important it is to avoid the court intervention when somebody loses capacity. One of the things that I want to clear up, because there's a lot of confusion on this, is that when people are married, they think, I don't need this durable power of attorney. I'm married. I live in Washington. We're a community property state. We've been married for 40 years, 50 years. Everything we have is ours. The house is in both of our names. Of course, I have a 401k in mine. There's an IRA in theirs, but our bank accounts jointly, both of our names, everything is ours. True. Does that mean that you are protected from a court-ordered guardianship if you or your spouse lose capacity? Well, it doesn't mean that. It is a very unpleasant surprise that couples discover when one of them has lost capacity and the other one says, I'm in charge of everything now, aren't I? Well, no, you're not. You do not have legal authority over the affairs of your spouse. Now, why people get confused about this is they say, well, we're on the joint bank account. Both of us can pay from the bank account. You are, not because of any legal authority from a document, but because you both are on the name and owners of that bank account. But how about your spouse's IRA? You can't do anything with that. What if you need to sell the house because it no longer works for you, and because your spouse has lost capacity, maybe you want to move to a different community? You can't sell your house. Why? Because your spouse's name is on that house title. So a couple, I'd say more so than even a single person, needs to have these durable powers of attorney in place to avoid the court. Because imagine the frustration for the well spouse when they just want to move forward with business and take care of things, but their hands are tied because they do not have the legal authority. And therefore, to get legal authority, their spouse is under a guardianship, conservatorship, and every single thing that they have to do when it comes to their property has to run through the court. Extraordinarily frustrating. Couples, please make sure that you have durable powers of attorney. It will protect your voice, your spouse's voice, your money. It will keep the autonomy that you want so that you can manage the affairs of yourself and of your spouse. Another thing that people don't realize why it's so important to have good durable powers of attorney, especially financial durable powers of attorney, comes back to the situation where somebody, let's say the spouse has lost capacity and they need care, and the couple doesn't want to spend down all of their money. And for those that aren't, super wealthy, long-term care costs are probably the biggest worry or concern that's on their minds, is that because you see it everywhere, and cost of care can exceed $10,000 a month. Certainly in a skilled nursing facility is much higher than that, but even some adult family homes or assisted livings could be 8,000 or above. So that's 100,000 plus per year. So a couple who comes into an elder law attorney is going to be saying, can you help us figure out a way that we don't have to impoverish ourselves, that we can use government benefits? To which an elder law attorney with Medicaid expertise is going to say, absolutely. We're so glad you came in. This is one of the things that makes us so happy, is helping you and your family protect assets and use government benefits that are available to you, because we understand what the rules are. With a robust estate plan prepared by an elder law attorney, it's no problem. We are going to figure out a great strategy forward. When, however, the couple that comes in and one of the spouses has lost capacity, they don't have a durable power of attorney, they're facing a guardianship. When they don't have an effective power of attorney, our hands might not be completely tied, but there might be restrictions or limitations on how good a Medicaid asset preservation strategy is going to be. The Medicaid asset preservation strategy, one of the things I really want to emphasize, it's so important. As an elder law attorney, and every elder law attorney I know, will never take action that will jeopardize the quality of care to the person who needs care. I mean, that's paramount. But when we can do a strategy that ensures there's going to be good care and preserves money and uses the benefits to pay for long-term care, we will do so. That is a way to protect money and protect the legacy. So I believe we have time. I'm going to give you an example of a Medicaid asset preservation strategy. I'm going to change the names up a little bit, but I'm going to use $1 million again. And the reason that I'm talking about this, I want to make sure that you understand the reason I'm talking about this is because with a good, durable power of attorney for finances, an elder law attorney can implement this strategy. If there is an inadequate power of attorney, we might not be able to do this. We likely won't. So here's an example of a couple strategy. They're both alive. Nobody has passed. One simply needs care. So in this case, we're going to take Betty and Fred. They've got $1 million, of which 500,000 is in their house and 500,000 is in what we call countable assets. That could be a bank account, a retirement account. Basically anything that is not countable is considered countable. And in Washington State, we do count 401ks and IRAs. We count retirement funds. In our case, we're going to have Betty, again, with advanced dementia. And they've got an estate plan. And Fred has cared for Betty in their home. But frankly, he is tired. He knows that he can't continue to take care of her. And that if he does, something is going to happen either to her or to him. And he realizes that she needs facility-based care. So I'm not going to dig into Medicaid's rules too much, but I will tell you that Medicaid counts assets of both spouses. And for community-based care, the amount of countable assets that the couple can keep is about $70,000. That's it. And remember what I just explained, they've got 500,000 in countable assets. The house, 500, non-countable. It's off the table. 500,000 that's in the bank, that is countable. Most attorneys and certainly care facilities will say, so sorry, spend down, spend down, spend down. An elder law attorney that knows Medicaid will tell you that how we preserve that money is that we will, first of all, find the facility that will take Medicaid. frankly, a lot of facilities, especially not the skilled nursing, they typically take Medicaid right away. But let's say that this is a memory care facility, and the memory care facility that's right for her says, we'll take Medicaid after a year. You must privately pay for a year. All right. Then that's going to be that spend down. But 1 year, we're going to take from that 500,000. They're going to pay probably 100,000 for her care over the 1 year. They still have 400,000. Are they going to qualify for Medicaid? Well, if you're working with our office, yes. And this is how. The money that is too much, and in this case, we'll say that it's 340,000. Medicaid's how much you can keep changes. It's gone from 60,000 to 70,000, but I'm going to use the 60,000 example. So we have 400,000. They can keep 60. What are we going to do with that extra 340,000? What are we going to do with it? Medicaid says you can't have it. We take that 340,000 and we put it into the name of the well spouse. So Fred is going to take that money, that extra money, and he's going to buy a Medicaid compliant annuity. The state allows you to have a Medicaid compliant annuity. What that does is that takes what is countable money and changes it to a non-countable status, an annuity. So by doing that, by taking that extra 340,000 and putting it into this Medicaid compliant annuity, this couple qualifies for Medicaid. Medicaid will pay for Betty's care. Fred does not have to spend down this money. He simply needs to buy the annuity, which is only purchased at the time of need. And you're going to say, well, what happens with all that money? He's going to get it back over 60 months. Calculation is for 340,000 over 60 months. He's going to get back basically $5,667 a month over the next 5 years. He gets to get it all back. It never again will cause anyone to be, or Betty to be ineligible for benefits. Her income that she gets pays for her care. State pays for the rest. Fred gets to keep the assets and his income. We've preserved money. We've preserved that monetary legacy for this family. How are we able to do that? Obviously, from having the Medicaid knowledge, but importantly, from having a good, durable power of attorney that granted the necessary authorities for us to do all the things that need to be done to make sure that Betty goes on Medicaid, the state gets nothing, the house will be only in Fred's name, the state doesn't have a lien on the house. It's a pretty good outcome, and all while supporting her care and preserving the assets for this couple. All right, so we have got a little bit of time left before the top of the hour. I just briefly want to mention healthcare power of attorney. Make sure that you have that where you name somebody who knows what your wishes are, such that if you are at end of life, they will speak your truth. That if you don't want heroic measures, you have a living will, healthcare directive, advance directive, all says the same thing, that says no heroic measures, and you've appointed an agent under your power of attorney for healthcare to be your voice, so that there's clarity, there is guidance, and the outcome is the outcome that you would want. All right, so I am going to see if there's anything in the chat or questions and answers that I can answer for you. There is one more thing, a question about POLST that I want to talk about. A POLST in Washington is it's this lime green form that is posted on your refrigerator, and it's not a legal document. The attorney doesn't provide it for you. It's something you get from your doctor. It's the physician's order on life-sustaining treatment, or POLST. What that is oftentimes, you hear from people that are perhaps have, they're aged, they have some issues, and they know that if their heart stops, they want that to be it. They do not want to be resuscitated. They think of it as DNR. So on the pulse form, it will say DNAR, do not attempt resuscitation. And in the event that that situation were to occur and the emergency responders are called, 911 is called, the only way under the law that these emergency responders can be hands off and not attempt resuscitation is if they see that pulse form, it's visible and it says DNAR. So that is an important document to help you control what your healthcare will be, but that's not something that you're going to get from an estate planning or elder law attorney. That's something that you will get from your doctor. Okay, well, that's all I have for today. If you have any, what is that document again? Thank you. It is called a POLST, Physician's Order on Life-Sustaining Treatment. If you go to your doctor's office and you look at all the things that they have on their wall, you see something lime green, that's it. So that's the, ask your doctor about that. Typically, it is a document, the PULSE document is only offered by the doctor of the patient when it is appropriate. If you are healthy and don't have any debilitating or terminal illness, probably not going to talk to you about it because it probably isn't appropriate. But always ask the question. The doctors, I believe, they have a way to talk to you about it and get paid for it. So, it's always good to find out information. So it's called a PULSE form. So for those of you who don't mind, you can take a look in the chat. If you have questions, feel free to reach out to us at ELG Estate Planning. Our phone number is 509-468-0551. We've got a website, elgwa.com. We've got a lot of resources there. I did want to share for those that want to get a little bit more sentimental, which you're probably saying, hey, I'm trying to figure out my estate plan. So no, that's not me. I appreciate you being here with me. For those that do, I wanted to share with you what I thought was just a very sentimental, beautiful poem that was shared at a service this week that I went to. And originally was called My Mother's Garden. It was changed to My Parents' Garden. And I'm going to share it. My parents kept a garden of the heart. They planted all the good things that gave my life its start. They turned me to the sunshine and encouraged me to dream, fostering and nurturing the seeds of self-esteem. And when the winds and rains came, they protected me enough, but not too much. They knew I'd need to stand up strong and tough. Their constant good example always taught me right from wrong, markers for my pathway to last my whole life long. I am my parents' garden. I am their legacy. And I hope today they feel the love reflected back from me. Author unknown. Again, thanks for being with me today. I hope you found it helpful. We'll see you next time.